So thank you everybody for joining us this afternoon at this fantastic event, which is being hosted by the Greater Birmingham Transatlantic Chamber of Commerce. And we also have friends here from Birmingham City University, the Centre for American Legal Studies again. And we held some fantastic events last year where we were learning all about the election process in the USA. And this is now going to be a bit of a follow-up event for us all to hear more about what's going on with the US Supreme Court. So Grace, if you can move on to the next slide, please, for me. I just wanted to share a little bit about the British American Business Network. Because the Greater Birmingham Transatlantic Chamber of Commerce is part of the network of 22 chapters across the UK and North America. And it is the one membership organisation that you can go to where you can get support for trade, but you will also have that voice that will be able to lobby governments on both sides of the pond on some really important issues. So if you can just go over to the next one, please, for me, Grace. I just wanted to share with you some up and coming events that we have, which are some are virtual and others will be physical. So we have had a really successful programme of events called Chapter Chat, where we get to hear all about the real benefits of trading with some of our partners, their chapters within relevant states. So we've got one coming up now with Carolinas, and that will be at the end of May. And then we will also be arranging one in the Northwest Pacific region. So please do have a look at that when we post that date, because it does give you an opportunity to learn more about what's going on over there in that particular state, but also we get a chance to share about all the great benefits of the Midlands region as well, so that we are collaborating. Now, I've put on there as well that we have this Select USA Summit. So this is a physical, in-person and a virtual event, and it's taking place in June. And this is with our friends at the US Embassy. So I wanted to make sure that you have this information so that you can have a look and see if it's going to be appropriate for you to maybe attend this event. You will be aware that the Transatlantic Chamber has got really strong links now with the US Embassy, because we hosted a great event back at the end of March with them. So if you need any further details on any of that, then please do get in touch. But I do think that we are now ready to start the event for the day. I've spoken far too much already because I know there's loads of information that our special guests are going to share from also in partnership with Pace University. So I'm now going to hand over to Anne Richardson Oakes, who is going to explain who is here to talk and the subjects that we're going to be hearing about. So Anne, over to you.
So thank you, Mandy. Thank you for that welcome. Thank you for that introduction. And I'm Anne Richardson Oakes, and I'm the Director of the Centre for American Legal Studies here at Birmingham City University. And we're a centre of excellence with a specific focus on US constitutional issues. And we're delighted to be partnering with you in the Transatlantic Chamber today. And as you said, this webinar follows our post-2020 election event in October 2020, and that election, as we know, brought an end to the presidency of the 45th president of the United States, Donald J. Trump. We couldn't then have foreseen the tumultuous events of January 2021, which culminated in the storming of the Capitol. But the implications of the president's actions while in office and on leaving it are still very much with us. And in particular, as presidents before him have realized, it is in many ways the nominations that they make for appointment to the US Supreme Court that can represent the most enduring aspects of their legacy. So with us today to discuss that legacy, we have a panel of 3 distinguished scholars from the Elizabeth Horb School of Law, Pace University, New York. And I'd like to welcome Professor Lisa Griffin, Professor Bennett Gershman, and Professor Katrina Koo. Thank you for joining us in this event. I'm going to bring you in one by one in that order, if I may. And our first speaker is Lisa Griffin. Professor Griffin is an expert in criminal procedure and comparative criminal procedure. She's written extensively on criminal law, wrongful convictions, and comparative criminal procedure issues. She's the author of 2 treatises on federal criminal appeals and multi-defendant criminal cases, and she teaches at the university, at Pace University, the Elizabeth Hall School of Law at Pace University. She's also a BCU visiting professor, and she's going to talk today about the events of January 6, 2021, and the legal consequences that have ensued. Thank you, Lisa.
All right, let me get my PowerPoint. Okay, well, thank you, Anne, and thank you, Mandy. It really is a pleasure to be here. My heart is in many ways in Birmingham, although my body is currently in Spain and my home is in New York, but I'm very pleased to be part of this. Yes, I recalled that in 2020 we had a similar event about the election, and so I thought maybe we should revisit the election since, yes, Donald Trump is no longer the president, but many people still refuse to accept that. And I thought that the situation in the United States is so chaotic about the election that it would help everyone to understand a little bit more about what actually is going on, including me, because it seems totally chaotic over there. So I wanted to talk about the legal and ethical issues that are rising as a result of the claim that the election was stolen by President Biden and that Donald Trump should still be the president. One of the subjects I do teach is professional ethics, and my focus in some of this discussion is going to be on the role of the lawyers in all of this stop the steal election challenges in the US, particularly in the US courts. So to start with the facts, here's the claim. The claims are basically that the election was fraught with fraud. Felons who were not allowed to vote in the US voted, dead people voted, people voted twice, although the only evidence of voting twice seems to be that Mark Meadows and his wife, Mark Meadows was the chief of staff of President Trump, did in fact vote twice in 2 different states. There are claimed absentee ballot forgeries, absentee ballot duplications. There were claims of trucks ferrying illegal ballots around the cities. And then, of course, the famous claim about the voting machines, that somehow they were tampered with in a way that I quite haven't figured out, but that involves Venezuela. Okay. Anyway, the evidence is that this election was considered the most secure election in American history. There is no evidence that any votes were deleted or lost votes, changed votes, or anyway compromised. Internal Trump memo said that the fraud claims related to the voting machines were baseless. William Barr, the then Attorney General, said there was no evidence of fraud, as did the Attorney General, who privately told Trump that they're not supported by the evidence. So that's the factual background. I want to talk about the litigation, the professional disciplinary proceedings, and the investigation, the January 6th investigation, because these are really 3 separate, unusual, unprecedented phenomena that are simultaneously taking place in the United States surrounding the election. Now, I will say that the Supreme Court, which is sort of our subject, has maintained itself to be uninvolved in most of this. But of course, all of it raises issues that could get to the Supreme Court. And so it's all in the shadow of the Supreme Court as we know it now, which is clearly has a majority of Trump appointed judges. Okay, so the first thing is the litigation. What is happening in the courts? Well, as of now, over 60 lawsuits claiming voter fraud have been dismissed all over the country in all different states and all different courts. There are currently some pending lawsuits against the Stop the Steal people for aggressive door-to-door tactics in trying to intimidate and investigate alleged voting fraud. At the moment, 60 lawsuits have been dismissed. And a good example is the case of King v. Whitmer in Michigan, in which the claim was made that the voting was fraudulent, and the relief requested was to name Donald Trump as the president. Well, here's just the details of that. The legal context was that several lawyers brought these claims, and the state moved to sanction them under Federal Rule of Criminal Procedure 11, which is sanctions for misconduct in litigation. Vexatious lawsuits, claims without factual support, lying to the court, maintaining lawsuits that are moot, defenses and claims that are not warranted by existing law, allows the court to impose sanctions on the lawyers who commit that kind of misconduct. 28 U.S.C. 1927 allows the court to impose excessive costs, and the court has inherent judicial power to sanction lawyers for misconduct in the courtroom. So the court found all of these elements of misconduct were present. It's an astounding 50-page, very well-reasoned decision by the court that substantiates that the pleadings were signed without having been read, that the lawyers lied to the court, that they brought the lawsuit not to succeed on the merits, but to create lack of respect for the voting process, that they maintained it after it was moot, that the defenses and claims were not warranted by existing law, were without factual support, were not supported by the law. And it's really difficult to share the shockingly dishonest, if you will, lack of preparation, lack of investigation that this lawsuit represented. The same kinds of claims that were made in the other 59 lawsuits were made here. There was no attempt to investigate or to elicit supporting affidavits. The lawyers got the law wrong. They relied on an expert who got the state wrong. And I think the most shocking thing was how there was really no factual support, as we said at the beginning, for their claims. It's important to realize that not only did the court impose sanctions on these lawyers, but she did refer them for discipline. The ethical duties, aside from the legal liability for misconduct, are listed here, and it's clear that this is a serious case for the disciplinary authorities to examine. I just have to share this with you because it came across this week, and I just find it unbelievable. Another litigation in Texas is against Stephen Holtz, who I believe is a large donor to Republican causes. He thought he had one of these claims that a white truck was carrying phony ballots. That was also made in other cases and not substantiated. He asked the U.S. attorney to help stop the van, but said if they wouldn't help, he would have someone do it himself. He did have as a private investigator ram the truck and forced the truck and the driver off the road. It turned out he was a repairman. He had no ballots, and they were charged with assault with a deadly weapon. From a lawyering perspective, I think it's important to see that at the deposition in the case brought by the driver, Holtz denied knowing anything about the investigation, even though he is in a recorded conversation with the US attorney talking about it. Okay. The other sort of unbelievable or unprecedented result of this election was disciplinary proceedings brought against Rudolph Giuliani, who you know was the president's private attorney. These are the model rules, the ethical rules he was accused of and found to have violated, not necessarily based on his courtroom conduct, but actually on his public statements to the press and social media, all over the place. And he was, in fact, immediately suspended pending investigation, pending a hearing of these charges. The very same charges that we started off with. It's not, I mean, it's uncommon to suspend a lawyer in an interim manner, but it's also uncommon to suspend a lawyer for public statements. There is some sense that he had a First Amendment right to say these things. He would have had a First Amendment right to say the Martians stole the election if he weren't a lawyer, but there are rules against lawyers making false statements. And so we have that disciplinary proceeding. And I guess the thing that most people have focused on are these two investigations, the Georgia investigation, starting with then President Trump, or saying, I want to find 11,000 votes, electing or appointing fake electors. The same thing happened in Pennsylvania. And that's an ongoing grand jury investigation in Georgia. Of course, the January 6th investigation is the big one. Apparently, they're going to start public hearings in 2 weeks. It raised a lot of constitutional issues, which I want to just touch on. And then, of course, the investigation of Mark Meadows and his wife, because they were voted twice. That's the only real election fraud that has come up after all of these investigations. So, the January 6th committee is a congressional committee. The legislature, the executive, and the judiciary are co-equal branches. There was an issue raised about whether the Congress had the power to investigate this president or to subpoena members of the executive branch. But it's clear that I think it's clear that Congress does. It has a very broad duty to investigate and to legislate and to impeach. And certainly, a long line of cases upholds its ability to subpoena members of the president's staff. There was a challenge to it because it doesn't have 13 members, but if you've been watching carefully, you'll see that Nancy Pelosi did appoint some members and did, as she was required to do, consult with the minority leader. It ended up with fewer members because the minority leader nominated people who were avowedly in favor of overturning the election. And then when Nancy Pelosi refused to put them on, the minority leader backed out of the whole thing. So that's why there are fewer members. That challenge has been rebuffed in the courts. And then I think most interestingly, the constitutional question of immunity. President Trump claimed the power to be able to tell his senior staff to ignore congressional subpoenas, and they did so. And the question became, can he do that? Do they have immunity, absolute immunity from Congress? And the answer is no. They have a duty to respond. There are privileges that they could claim to protect communications at the request of the president, but those communications would have to be about official presidential duties. And I think a good argument can be made that overturning the election and interfering with the lawful process of counting votes, electors, is not an official presidential duty. There's also a crime fraud exception, which could apply here, since that interference is also a crime. And even if there is a privilege, the courts would have to balance the confidentiality against the need for the information, and clearly an attack on the Capitol is going to be considered important. And of course, as we all know, Trump doesn't have the power to invoke the privilege. Now President Biden is also involved, and President Biden's vote counts more than President Trump's. So the only thing the Supreme Court has done is they denied an application by President Trump to prevent release of presidential records that are being held in the archives. It was unanimous, there was no reason given, and Justice Thomas dissented, which caused everyone to wonder whether there was any impropriety since his wife was involved in the January 6th event. And so that's sort of an open question. Steve Bannon was indicted for refusing to appear. He was a private citizen at the time. Navarro, Scavino, and Meadows have been referred by Congress for a contempt prosecution, but the DOJ, the Department of Justice, has not acted. Maybe because maybe because Bannon, being a private citizen, it's pretty clear he had no privilege. Whether Meadows, Scavino, and Navarro have a privilege would ultimately end up in the Supreme Court if they challenged it. And so maybe that's not a great place to go right now for the Department of Justice on that issue. Now, I guess I don't have time to do any more, but there's an interesting issue of attorney-client privilege raised by Eastman, who was the legal architect of the Stop the Steal strategy. And so far, it seems that there is no lawyer-client privilege because, again, the crime fraud exception applies, and the two of them at least seem to have conspired, one judge found, to obstruct governmental function, which is a crime. So I think I overstayed my welcome as it is. I hope that was helpful. It is sort of a circus, and I'm happy to answer any questions at the end.
Lisa, that was great. Thank you very much. I'm sure there will be questions at the end. I mean, it's something that we, if you find it difficult at your side of the pond to get your head around it, just imagine what it's like for us on this side of the pond. So our next speaker is Professor Bennett Gershman. Professor Gershman is Distinguished Professor of Law at the Elizabeth Hobbs School of Law. He's an expert on constitutional affairs and a leading authority on prosecutorial misconduct. And prior to coming to PACE, he was a prosecutor in the New York State Anti-Corruption Office, where he argued cases in state and federal courts involving public and political officials charged with corruption. And Professor Gershman has published extensively within the field and has a well-developed media profile. He's routinely quoted by the New York Times, the Washington Post, the Los Angeles Times, and the Wall Street Journal, as well as by local publications. He's an engaging and popular speaker, and his talk today will focus on current issues at the US Supreme Court. Bennett, please.
Okay, thank you, Anne. Thank you, Mandy, for putting together this program. Well, what can I say about the Supreme Court? A lot, but I'll try to confirm myself to a few minutes. Where do I start? Even before the two recent bombshells landed, the popularity of the Supreme Court was at an all-time low. What are those two bombshells? Well, you know, of course, the leak of the draft opinion overruling Roe v. Wade last week, and the disclosure by the Washington Post of the fact that when the Supreme Court turned down Trump's request to block the release of his doc records and so on to the select committee investigating the January 6th insurrection, there was one dissent, Clarence Thomas. But it was disclosed several weeks ago that at that time, Thomas's wife, Ginny Thomas, one of the most reactionary Republican zealots in America, who really occupies a very prominent place, was in secret conversations with Mark Meadows about how to stop Biden from gaining the presidency and how to restore Donald Trump to the presidency. She's the wife of Thomas, and Thomas dissented from the release of records. Many of those records were involved in communications between Thomas's wife and Mark Meadows, the chief White House. The popularity of the Supreme Court, only 40% of Americans think the Supreme Court is doing a credible job. 54% feel that the Supreme Court has been the most partisan institution that they can remember. Why is the Supreme Court broken, which many commentators say? Why is the Supreme Court so unpopular today? And I think we can trace it maybe over the last 10 or so years. I would trace it, I would begin with the decision by the court, the Citizens United case, where the Supreme Court held that political campaign contributions are free speech, and that unleashed a tsunami of dark money into political campaigns, something that we've never seen on that scale ever before. Many of these secret organizations are allowed now to contribute unlimited sums of money. We saw it a few years later where the Supreme Court struck down a critical provision of the Voting Rights Act, which required states which had disenfranchised African-American voters to get a clearance from the Justice Department. The court in Shelby County versus Holder said, we don't need that anymore because race is no longer a problem in American democracy. We know that is about as dishonest as we could say. Most Americans, I see the court as partisan, the way it's never been before. For example, if you took any issue with the court where it's being argued, and you tried to figure out which side the Republicans would support, once you conclude which side the Republicans would support, I will bet you that it's likely 90% likely that the Supreme Court would decide the case that way. And in addition to just the partisanship, many people feel that the court, based on the decisions that it's been making with respect to religion, the court has, in effect, embraced this theocratic vision, which they are trying to impose on the rest of America. And don't forget this, when we think about the Supreme Court's legitimacy, we know that the conservative majority on the Supreme Court have been appointed, or let's say nominated by a president who lost the popular vote, Trump and Bush. They lost the popular vote, and confirmed by a Republican Senate, which represents 20 million less voters than Democrats. So I think you can sort of see this irony that the Supreme Court is really a minority institution which is enforcing the law, the Constitution, on a majority of Americans in the way that they're doing, and which potentially includes striking down abortion protections, criminalizing abortions, criminalizing contraception, reversing the protection of persons of the same sex to get married, reversing the protection of persons who want to engage in consensual sex, restricting harshly immigration, allowing states to skew voting districts and disenfranchise voters. I mean, I could go on and on here, but it seems to me that's a fear that the majority of Americans now have. The confirmation process contributes to its unpopularity. The confirmation process we know has become toxic. Obama nominated Merrick Garland to the Supreme Court. The Republicans in the Senate hijacked that nomination. They would not allow Garland to even get a hearing. Why? Because they said that they want the next president to be able to appoint the next Supreme Court justice. But that election was 10 months away. And we know that after Trump took office, and he nominated Neil Gorsuch, who is one of the three arch conservatives on the court, along with Thomas and Alito. They make up like a triumvirate of the most reactionary Republican conservatives ever to sit on the court. We know that in the waning days of the Trump administration, Ruth Bader Ginsburg passed away. And Trump then nominated Amy Coney Barrett. And here the Republicans are saying, no, we don't think the next president, and this is, by the way, weeks before the election, we don't think the next president should appoint. We're going to allow Trump to make the nomination, and they confirmed Barrett, even though the election was, as I say, a few days away, actually. And then just remember the way the Republicans on the Senate Judiciary Committee, the vicious, disgusting, despicable way they assaulted Ketanji Brown Jackson, one of the most distinguished nominees, the first Black woman nominee in the Supreme Court's history. I mean, it was absolutely disgusting what they did. Another reason, there's no ethics code for the Supreme Court judges. The only judges in America where there's no ethics code that regulates their behavior. Obviously, if there was, Thomas would never have been able to sit on a case where the committee was seeking records where Thomas's wife was involved in those records. But I think people see that as hypocrisy. The secrecy of the Supreme Court has always been a problem, and we know that they never would allow their proceedings to be open. We don't know how they decide cases. And the secrecy has now morphed into what people now refer to as the shadow docket. Let me take a couple of minutes to talk about the shadow docket. The shadow docket is a nickname for an emergency action by the Supreme Court where there is an emergency. For example, in death penalty cases where a prisoner is about to be executed, the Supreme Court will step in. In an election case, let's say where a candidate has been disqualified by a court and the election is next week, the court might step in. But the number of cases in which the Supreme Court has used this emergency power is like in the single digits every year. In the last several years, it's been over 20 emergency actions every year. And while the emergency docket, yes, it's secretive, it's irregular, it's unreasoned, but it's something that the Supreme Court has used sparingly. Now they're using it in this way that is widespread. They're doing it where the impact is not just on one single case, but on the entire country, and where there's no briefing, there's no argument. It has precedential effect. Let me just quickly. The Supreme Court has used the emergency, the shadow docket, the emergency docket to let stand the Texas anti-abortion law. They blocked a nationwide vaccine and testing mandate. They reinstated a Trump anti-environmental regulation that allowed states to block pollution by companies. They stayed an order by the lower court which said that Alabama's redistricting violated the Constitution. They stayed that, which would have affected the upcoming election, and said, well, we'll hear arguments about it later on after the election. But at the same time, and that law favored Republicans. At the same time, they struck down a Wisconsin decision by the Wisconsin State Court that said that the districts in Milwaukee had to add a district for Black majority voting. And the Supreme Court, that was heavily favored the Democrats. The Supreme Court struck that down. So it seems to me that this, that all of these reasons which I've tried to are contribute to the Supreme Court's decline in popularity. Just very briefly, the draft decision of Roe v. Wade, it's a draft decision. We don't know whether it's going to be the decision of the court. There's nothing crazy about that decision. It's within the way a conservative court would talk about due process. I mean, they talk about due process as historically rooted in tradition. And obviously, there's no historical tradition for abortion. They talk about how the Supreme Court reaching out will usurp the democratic process. We know that. And I think Alito's draft was extremely, the tone was extremely an attack on the court in Roe v. Wade for egregiously incorrect, sloppy reasoning. It's all predictable. There's nothing strange about it. What we can predict is, even though the court said this doesn't mean that we're going to do anything with contraception or gay marriage or whatever. People are obviously feel that this conservative court will move in that direction and eviscerate many of the fundamental rights that are now being protected. Okay, just one more, looking ahead. This term, the Supreme Court will decide 3 religion cases. One they've already decided, where they said that a Christian flag would be allowed to be flown in the city of Boston, the question is whether Maine could be needed to fund the use of state money, where the money was going to persons seeking instruction in religious schools. And there's a case involving a coach who prayed in a football game, and whether the coach would be allowed to prayer, open like that. The court's going to decide a gun case from New York, where for the first time the question is whether or not the persons have a right to carry guns. Before, the Supreme Court said persons have a right to have guns in their home. This is an open carry law. And the court might very well touch on Chevron deference, where the Supreme Court has said that if an administrative agency has a reasonable basis for enacting regulations, the court must defer to that Chevron deference. But there are several justices who hate Chevron, and it's very likely that the Chevron deference decision will be overruled. The Supreme Court will decide a big affirmative action case next term from Harvard and North Carolina. My guess is they'll strike down affirmative action. There's a case coming relating to New York Times and the defamation law, which is very, very protective of the media. The Supreme Court could touch on that. And there are other areas where the Supreme Court will use its muscular new conservative majority to revamp what we've seen as constitutional law over the last 50 years. So that's all. Thank you.
Oh, thank you, Bennett. Thank you. And lots to talk about there, and lots to engage with. But before we do so, I'd like to come to our final speaker, who's Professor Katrina Fisher-Koo. And Professor Koo is Held Distinguished Professor of Environmental Law at Pace University, which she joined in 2017. And she was previously on the faculty at Maurice A. Dean School of Law at Hofstra University, where she was Professor of Law and served as an Associate Dean of Intellectual Life. Now, her scholarship focuses on climate change and sustainability, and she teaches environmental law, international environmental law, global climate change, and US law, administrative law, and torts. And she's going to be speaking to us today on current legal issues of environmental concern, including, I think, the enduring legacy of the Trump era. Thank you, Katie.
Thank you. Thank you so much to Anne, to Mandy, to Stephanie, to Grace, and everyone at the Chamber, and also Lisa for making the introduction. What I'm going to talk about today is I'm going to focus on the Supreme Court's role in environmental law and policy in the United States. And you're absolutely right. A big part of my discussion is, as Bennett had also mentioned, indexed to the fact, I think, caused by the fact that we have 5 Supreme Court justices who were appointed by presidents who lost the popular vote, and that's a big piece of what's going on. So what I'm going to suggest to you is that when you hear about the Supreme Court and environmental law and policy in the United States, you will increasingly hear the Supreme Court embrace the principle that it should be Congress and not the court that should decide core environmental policy. And what I'm going to submit to you and try to illustrate to you by taking a close look at the Supreme Court's engagement with climate policy in the United States is that although that principle sounds neutral and it sounds pro-democratic, in fact, in implementation, the Supreme Court is applying it in a way that is ideological, one-sided, anti-democratic, and frankly abdicates the court's role in a constitutional democracy. So to start, before we can start talking about the Supreme Court's role in U.S. climate policy, we have to talk about U.S. climate policy. And the key point here is that the U.S. doesn't really have climate policy. Although the United States is once again a party to the Paris Agreement, although we have committed to our nationally determined contribution to reduce roughly half our emissions from 2005 levels in 2030. And although the headlines are consistently full of all of the evidence that climate change is currently occurring and having dramatic and awful impacts, the United States still does not have a framework climate change law. And by that, I mean a comprehensive federal law designed to reduce emissions in the United States. I think quite appropriately in response to that, in a constitutional democracy, many advocates who support climate action in the United States have come to the courts and said, do something. And they've come on 3 primary theories in an effort to persuade courts in the United States to support, prompt, or strengthen US climate policy. These 3 pots are: first, they've raised claims arguing that it's unconstitutional for the federal government to adopt policies that exacerbate climate change. They've also directly sued large emitters of greenhouse gases or fossil fuel interests, arguing that seeking court orders and joining them to reduce their emissions or pay damages. And they have also come to the courts and asked the courts to interpret existing statutory authority, namely the 1970 Clean Air Act, to require further reductions in emissions. And I'll go through each of these in turn. But in short, the takeaway in each of these contexts is that the US federal courts and the Supreme Court in particular have consistently declined the invitation to opine or to use these legal theories in a way that would prompt the legislative branches to take stronger climate action. So first, turning to those constitutional claims, the most significant lawsuit here is Juliana versus United States, was a lawsuit brought by a group of miners against the US federal government, arguing that the federal government's policies, including continuing to allow the extraction of fossil fuels from public lands, was contributing to climate change in a way that violated their rights under the US Constitution, and specifically their due process rights, their substantive due process right to a stable climate system. The district court in this case held that they had stated a claim and held that there could be a fundamental right to a stable climate system protected by the US Constitution, and set the case to go to trial. However, before that could happen, the case was dismissed by the Ninth Circuit Court of Appeals. The quotation that I've given you outlines that the Court of Appeals' decision to dismiss the case, grounded in its finding that the court did not have the power to order the US federal government to adopt climate change policies, was really a way of courts, the federal courts in this case, supported here by the Supreme Court in some commentary that they included on denials of the petition's mandamus actions that actually had gone up to the Supreme Court in this case, really suggests it's courts in the United States don't have power to set climate policy. It has to be Congress that does it. When litigants went and sued emitters directly, so these are common lawsuits that were brought under the federal common law of public nuisance and were brought directly against fossil fuel companies and large emitters of greenhouse gases. And the argument was, if the government isn't going to use its public law power to compel you to reduce your emissions, we're going to use our common law theory, i.e. the actions that you're taking are producing emissions that are contributing to a public nuisance, and you need to reduce those emissions and or pay us damages. The case that went up to the Supreme Court on this theory was American Electric Power Company versus Connecticut. And in that case, the Supreme Court held that Congress had already decided that decisions about the volume of emissions from these sources were to be made by the Environmental Protection Agency under the Clean Air Act. And therefore, because Congress had adopted a statute that spoke to these issues, there was no room for a federal common law theory or for the courts to further opine. So here, what the courts seem to be saying, what it wasn't Congress needs to decide, the courts seem to say Congress has already decided what the emissions should be from these sources in the form of the Clean Air Act, and therefore there's no room for courts to order further reductions. Well, that sounds great until you look at how the Supreme Court has interpreted the Clean Air Act. So the question then became, could the Clean Air Act adopted in 1970, the authority afforded by that statute, actually compel meaningful reductions in US emissions? There has been some progress here. The Supreme Court has allowed the Environmental Protection Agency to promulgate emission limits on tailpipes for vehicles under the Clean Air Act. However, to date, no court has permitted the Clean Air Act to be interpreted to require the types of emissions reductions that will really be necessary for the US to significantly meet its mitigation goals under its nationally determined contribution. So the Supreme Court has seemed open, and in this case, Utility Air Regulatory Group versus EPA. The Supreme Court was willing to uphold an EPA regulation that had interpreted the Clean Air Act to require some controls on greenhouse gas emissions from new or modified sources of greenhouse gases. So if you wanted to go out and build a new power plant, they said EPA could go ahead and subject your power plant to some controls on its emissions. However, if you read the decision, throughout the decision, the Supreme Court's offered what I think of as a shot across the bow, or some language that suggested that it would be very wary of any interpretation of the Clean Air Act that would apply emissions reductions to existing sources in ways that might cause them to go out of business or might have significant economic repercussions. When President Obama was in office, he instructed his EPA, and his EPA did, attempt to use its authority under the Clean Air Act to go directly after large existing sources of greenhouse gases in the form of, for example, existing coal-fired plants, which generate roughly about 30% of existing existing emissions in the United States from the electricity sector. EPA promulgated a rule that would have caused a number of these existing facilities perhaps to go out of business. The Supreme Court took the unusual step at that point of staying the implementation of the rule until legal challenges to the rule concluded. Because President Trump was elected, which is a nice connection to this follow-up conversation today, the courts never decided on that rule, and instead President Trump's EPA promulgated a different rule that required almost no emission reductions from those existing coal-fired plants. That rule was struck down by the DC Circuit Court of Appeals, and the Supreme Court has now granted cert. And based on the questions on which the Supreme Court has granted cert and the arguments that the questions that they asked at oral argument of the litigants in that case, it seems likely, and here I'm offering a prediction, and you'll see I have put a little star next to my conclusion here. I'm offering a prediction that the court is likely to be miserly in its interpretation of the authority the Clean Air Act gives to EPA to adopt these regulations. So to recap, what do we have? When litigants have attempted to bring constitutional claims, the courts have said Congress has to decide climate policy. Courts don't have the power to do it. When litigants have attempted to bring common law claims directly against emitters or fossil fuel interests, the courts have said Congress has already decided this issue under the Clean Air Act. All we can do is enforce the Clean Air Act. And when it comes to enforcing the Clean Air Act, the Supreme Court has declined to do that in a way that would require significant emission reductions. And they have invoked this idea that the terms of the Clean Air Act are general, and because applying them to these large existing sources of greenhouse gases would have significant economic and social impacts, they need Congress to be even more clear in giving them authority. So basically the message we're getting from the courts is core climate policy needs to be decided by Congress. It can't be set by the courts. Don't really have a role in deciding that policy. And that doesn't sound so bad, right? So we have really healthy national support for the adoption of greenhouse gas legislation. No big problem, right? Just go back to Congress and we can get a federal climate law enacted. However, and now I'm going to share a different screen for you. let me show you the difficulties with that. So that national polling sounds great, but things get a little bit more difficult when you look at county level polling with respect to climate change. So here you have the red and orange suggest over 50% support, and the kind of blue tones suggest decreasing support. It all looks pretty good when we look at questions like, is global warming happening? Are you worried about global warming? All looking pretty good. Even with respect to the specific question, should Congress set strict CO2 limits on existing coal-fired plants? Still a lot of support. And that's, by the way, precisely the question that's before the Supreme Court right now. So why is it that we don't have federal climate law? Well, if you dig a little bit deeper here, is global warming caused mostly by human activities? We start to see a lot of blue. Will global warming harm me personally? A whole lot of blue. And then the key question, should global warming be a high priority for the next president and Congress? Again, a lot of blue. So the significance here is the location of that blue. And when I'm talking about the Supreme Court's insistence on only Congress can decide and the court doesn't have any role in moving climate policy, and my comment that is to some extent anti-democratic and enhances this bad dynamic in US environmental law where it's become mired in anti-democratic political gridlock. It's in part because of some of the dynamics that Professor Gershman referred to earlier, namely, all of those blue areas, those states, each have 2 members in the Senate. So in the Senate right now, we have over 202 million Americans represented by senators who would happily adopt federal climate law. However, we have roughly half of the Senate who represent only 160 million Americans who've been effectively able to block it. So when the Supreme Court says, takes the view that Congress needs to decide core environmental policy and courts don't have a role, we should be mindful that that is largely the product of 5 justices who were appointed by presidents who had lost the popular vote, locking in preferences of an actual minority of the country when it comes to adopting climate change policy. Thank you.
So thank you, Professor Koo. That was great. There's so much to talk about. It's difficult to know where to start. Do we have any questions from in the chat, Mandy?
No, we haven't had any come in, Anne, so more than happy for you to have a chat between yourselves for the last 5 or 6 minutes of the event.
That's great. So I have a question. It's primarily for Professor Gershman, but I think Lisa and Katie, you're going to have a view on this as well. And it concerns, it relates to the United States Supreme Court and the role of the Chief Justice, John Roberts, and who commentators seem to think is battling and feels the weight of his responsibility to maintain the legitimacy of the court. And I wonder if you'd like to comment on that and the extent to which he's likely to be able to retrieve anything from the situation that we're seeing and that you've been talking about at the moment.
That's a great question. And of course, he's going to try. He has already shown independence from the conservatives on the court. He's a conservative in criticizing the court's use of the shadow docket. He's done that recently. And I think people think that the reason the draft opinion by Alito was leaked, and we think it was leaked by a conservative who wanted to lock in the majority opinion overruling Roe v. Wade out of fear that Chief Justice Roberts would be able to strong arm another justice not to overrule Roe v. Wade and to take it incrementally, uphold the Mississippi law, but not overrule Roe v. Wade, because I think Chief Justice thinks that would be very destructive of the Supreme Court's legitimacy. And so by leaking the opinion, the draft opinion, it sort of puts those justices who joined the opinion in some jeopardy if they should change their vote now that it's become public as to where they were voting. I think it's a tremendous challenge for the Chief Justice, because I don't know that he enjoys the support of the five of the conservatives, who I think see their mission in this extremely aggressive way. But that's the great question: whether Chief Justice Roberts can save the court's reputation. Yes, and the answer is uncertain.
Of course, one of the problems with the Chief Justice, of course, is that the Republicans have never really forgiven him for the decision in Sebelius. And I mean, Lisa and Katie, I don't know if you want to come in.
Well, I would just say that, yeah, he's in a very tough spot. I mean, once Coney Barrett came on the court, he was clearly outnumbered. You know, I think that one of the problems he's going to have now, too, is that the way the court decides cases is to circulate drafts. And we've all known that. And we've all known that for years and years and years. All the, you know, tell-all books about the court have described that process. And, you know, I'm sure that some of our most revered decisions, we wouldn't want to see the drafts, you know, that were circulated. And I think that's really going to be a problem for him, because that deliberation process is now potentially damaged, the trustworthiness of it. It's got to be a collaborative court. And like every other institution, it suddenly isn't collaborative. You know, the collaboration was broken. And that really worries me. I think the other thing is that, yes, he would prefer not to overrule well-accepted precedent. It really wasn't necessary to do that in this case, consistent with conservative views. And I hope that we haven't seen the final decision, but I think he's going to have even a harder time now with one hand tied behind his back, since the deliberative process has been damaged.
Can jump in and add, and actually I think in my answer probably will touch on the question that David Green has asked in the chat. So Mr. Green has asked, it appears no matter which direction you go, elected officials or appointed judges represent or decide for fewer than 50% of Americans. So both of those avenues seem shut. What's the legal plan of action for the future? And to tie this back in with the prior question and Justice Roberts, I would say in the climate change case that's pending before the Supreme Court right now, advocates, I think, have given someone more moderate like Justice Roberts a lot to work with in the following sense. The legal theory that the very conservative judges would like to invoke to deny EPA the authority to regulate existing coal-fired plants is to make the argument that allowing EPA to do that would have such large social and economic consequences, because it would effectively cause those coal-fired plants to be shut down, that Congress has to speak directly to it. What's interesting is that over the last 10 years, it's become harder and harder to argue that it actually would have such huge social and economic impacts to shut down those plants. Why? Because advocates have been so successful at using what we call private environmental governance approaches to go after the really dirty fossil fuel interests. What does that mean? Through divestment campaigns, support for renewable energy, and a host of non-public law interventions, we've effectively been able to make progress toward our goal such that it no longer seems so like such a huge, it wouldn't have such huge political, social, and economic ripples to recognize that the existing coal-fired plants are going out of business. They're going out of business anyway because of the pressures we've been able to create. So when we can't, and I would say we're focused a lot on using those shareholder actions, divestment strategies, and other to create dynamics that can support someone like Justice, perhaps a decision from Justice Roberts.
Thank you, Katie. Have we got any more questions in the chat? Let's see. So how are we doing for time, Mandy? Because I think we could, I think this panel could carry on for the
I
next.
know you could. I mean, there is so much information. Thank you to everybody today for that. And I am just so glad that we were recording this, because I know that there will be many people that will be interested in hearing what you've had to say. It's always a pleasure to welcome you. And I think as we don't have any further questions, it's time for us to close the event. But if I can just say on behalf of the Greater Birmingham Chambers of Commerce and the Transatlantic Chamber Division and the Executive Committee, thank you very much for participating today, to you, Anne at BCU, and Katie, Lisa and Professor Bennett as well at Pace University. So thank you very much.